Employee monitoring software can be a very useful tool for small businesses who want to monitor their employees, track and improve employee productivity, and maintain company security. However, there are a few legal and ethical implications that small business owners should be aware of before they implement employee monitoring software. I'm Skye Schooley, a staff writer with business.com, and today I'm joined by David Miller, a labor and employment attorney with Bryant Miller Olive, to discuss the laws and ethics of employee monitoring. So, what federal and state laws should employers keep in mind before using employee monitoring software?
What I'm talking about here primarily, what's foremost in my mind is software that monitors the use of an employer's digital systems, which these days just spans the spectrum and it's expanding at all times. So the law is notoriously behind technology. That's never been truer than it has been today. But as a general proposition, federal laws don't put any restrictions on that kind of monitoring. Although there's one special exception that I'm going to talk about in a minute. I'm certain that there are special cases. For example, if your company is a defense contractor or works for HSA under some kind of contract. I'm not familiar with those kinds of things. Those would be special cases. And if your business is engaged in that kind of contract with the government, then you certainly are going to want to know what's in your contract and what that contract makes you subject to, because there's no doubt that there is some of that. For example, I know of, let's talk about law firms. Law firms will often contract with banks, and banks, the financial sector, very, very concerned about data integrity and security. And so I've seen contracts in the financial sector in which these entities will impose very strict security protocols. Now, I've never seen one that actually says you'll monitor your employees, but I'm sure that's not outside the bounds of possibility. So that's the federal side. State laws, of course, 50 states, 50 sets of laws or more. They vary tremendously. So employers are going to have to really look to counsel barred in their state to be sure that they are compliant. I practice in Florida. Florida doesn't really have anything of general application that would restrict that sort of monitoring. However, all states have some kind of invasion of privacy laws of some sort, whether it's merely a common law tort of invasion of privacy, or, and Florida is a good example of this, Florida's Constitution actually has an invasion of privacy or a right of privacy in its Declaration of Fundamental Rights. And you can be sued under that. So it's possible to step over those lines. So again, you've got to consult counsel in your state about those kinds of things. Now, the special exception that I mentioned on the federal level is the National Labor Relations Act. The National Labor Relations Act is the federal law that governs private sector employer union relations. There are aspects of the NLRA that apply to all private sector employers that are covered under the Act, which is most of them. And this happens to be one, what I'm going to talk about right now. There are very few employers in the private sector who actually have unionized workforces. It's only something like about 6% of American workers are represented by a union in the private sector, a little bit higher than that in the public sector, but in the private sector, very few, and that's been declining for years. Last year there was a little blip up, but that's a statistical thing. However, this, what I'm going to talk about applies to all private sector employers, and that's policies regarding email and digital communications. The NLRB is a 5-member board that is appointed by the president. And so what happens is that every time there's a change of administration, and in particular a change of party in the White House, you will see this back and forth of law under the National Labor Relations Act. There was a decision years and years ago that I love to quote, in which the administrative law judge had some words about the ebb and flow of National Labor Relations Board decisions. And it's just true. So under the Obama board, you had some decisions that came out that were very permissive toward employees using employer digital communications, and some decisions that addressed employer policies on the use of company email and so on. And there was even a suggestion, I don't know that it ever went as far as to squarely hold this, but even a suggestion that a policy that simply banned employee use, personal use of employer email, that might be held to be illegal under the National Labor Relations Act. Now, I don't know if you're familiar or if you've seen many of these policies, but a huge number of employers have policies that say just that. Company email is for company use, no personal use of company email. When the Trump board was fully seated, and there is a lag time because it's an appointment process, has to be voted on by the Senate, and these terms of the members are staggered. When the Trump board had a majority, all of those cases got rolled back. And then you were back to, no, it's all fine. The employer can require you not to use the email system. Well, guess what? There's been another change. There will be, the Republican appointed majority on the board will change as of September of this year. There'll be an appointment, and at that point, the Republican majority will be gone. So sometime late this year or early 2022, you can bet that you'll see a lot of these decisions, and I'm sure this one is one of those, that are going to be, it's going to ebb or flow, whichever direction we're going, back the other direction. And so what you're going to see is a lot more permissiveness for employees to use, not only use, but to use in with some expectation of privacy of employer digital communications. Now, I just said a very key word, key phrase, expectation of privacy. We're going to return to that again and again and again. That is the key. Does the employee have a reasonable expectation of privacy?
Awesome. And that actually goes into a question that I was going to ask later on, but we can just jump right to it, was, can employees expect any sense of privacy? I know you had just mentioned possibly with the email. Are there any other activities or type of information that they use company devices for that they could expect not to be monitored?
There are, and it's going to depend a lot on that phrase that I just used, the expectation of privacy. What goes on in your particular workplace? How does the employer view the use of its digital information systems? So now we're broadening out from just communications to any kind of information storage and use system. And is there a policy? What does the policy say? Are there exceptions in the policy? And critically important, you can have the strictest policy in the world, but if you, as the employer, don't enforce it, then you've set up a situation where an employee, because of the way things are around here, has that expectation of privacy. So, for example, let's say that the employer has a policy that says no personal use of email, no personal use of our computer system at all. But everybody knows that they're going to send out, hey, we're going to lunch now. Do you want to join us? Hey, there's a happy hour after work today. Hey, I've got kittens. Does anybody want one? Things like that, if they're tolerated And I mean, who's going to be such a Scrooge that they're going to, come down on the kitten message, very unpopular, are going to undermine that policy, and they're going to set up an expectation, because you'll be able to point to it: 50 kitten messages, 500 happy hour messages. You never punished anybody. Now suddenly I've sent an email. Let's take it out of the union context. I've sent an email to my doctor about my medical condition and my appointment tomorrow afternoon. And employer, you looked at it. That's private. And because you're not looking, or you're tolerating the kitten messages, you sure as heck can't look at my medical information. So there you've got a reasonable expectation that has been created by the employer tolerating this use of its digital systems.
That is very interesting. I actually did not know that. What potential legal implications should employers consider when, or keep in mind when they are monitoring their employees?
Well, they need to know the regime that they've set up, what we have just talked about. And clearly, from a legal standpoint, it's best for the employer, I mean, best in the sense of minimizing possible liability, to have that strict standard and to enforce it strictly, whether that's by monitoring and keystroke monitors. And I'm going to show a little bit of my lack of technical expertise here, because keystroke monitors, that could be totally passé by now. I know they existed at one point or another, but by enforcing those policies. But if they haven't, and if they view information, let's say you've got a keyword monitoring software, and it's going to pop up whatever words you put in there that you don't want being used in your system. And so typically we're talking about obscenity and profanity and things connected to pornography, but it might also be particular phrases or words that are linked to trade secrets, for example. And so if that pops up and you've got this software looking for that stuff, and that pops up, well, let's say that it wasn't one of those situations, but let's go back to the medical example. For whatever reason, there's one of these key words when the employee is sending information to his doctor and talking about some medical condition. I think pretty much everybody would agree that medical information is right in the core of what we expect to be private. So that pops up and the employer sees it. The employer's IT monitor sees it. Somebody's looking. Eventually it gets out of the realm of robots in your IT system, and some human being is going to read that. Well, if I'm the monitor and I see that the employee has popped up this medical thing, well, if I'm smart, I'm going to see that, I'm going to delete it and not look at it. If I'm not smart, I'm going to read it. And if I'm really dumb, I'm going to save it someplace. Now, I may be following my protocol. It may be that when these things pop up, I'm required to read each and every one of them. Or maybe I'm required to save each and every one of them so somebody can come behind me and check me. But if I do that, the more this information is read, the more human beings read it, the more the information is handled, so to speak, saved and stored and whatever, the deeper the hole is being dug. And if you have not eliminated, you as the employer have not eliminated that reasonable expectation of privacy, then when an employee finds out that you read all about their gallbladder issue, they're going to be miffed, and probably rightly so. So you've got to be careful in that way. And as I say, the easiest way to do it is not to allow that reasonable expectation of privacy to exist. And if that makes you a Scrooge, well, maybe better a Scrooge than the defendant in a lawsuit that you're going to lose.
That's awesome. In addition to those legal implications, are there any ethical implications that employers should keep in mind when monitoring their employees?
Every lawyer who has come through law school has had this happen. And this happened to me in my first year of law school in contracts. The contracts professor asks a question and somebody pipes up and says, well, that's just not fair, whatever it was that was under discussion. The professor, of course, was waiting for this, and he pounced and he says, this is the law. This is not philosophy. If you want to talk about ethics, down the hall to Dr. Philosophy's course. So ethics are squishy. Ethics are not necessarily the law. However, many states and localities even do have legal ethics codes. And particularly in the public sector, or if you're dealing with government from the private sector, these ethics codes will apply, and they can be very broad, and you can get debarred from doing business. You can pay fines, and we're not even talking about the bad publicity that comes from being formally labeled unethical. Nobody wants that, or very few anyway. So yes, but ethics at a more granular level are very personal, and they are a cultural phenomenon. And we in the United States are a very, very multicultural society. And so one person's ethical rule is going to mean nothing to the next person. So it's very difficult and probably often inadvisable to attempt to impose an ethics concept on a large group of people. Now, some places do, and in the private sector, you're certainly entitled to do that as long as it doesn't step over some legal line. For example, discrimination or that sort of thing. But we see those sorts of things in the news more and more frequently now. Easier by far to stick to the law. The law is there in black letter and in the opinions of judges, which are not black letter. But it's a whole lot easier to say, I'm sticking to what this law says. That's what I'm going to enforce. It's clear. Stay by that and you'll be fine. Rather than to say, I have this ethical feeling in my heart, and that's how I'm going to run my business. And all of you other people, whether you have the same feelings in your heart or not. Very difficult. You're entitled to do it in the private sector. Absolutely. Is it difficult? Can it get you in trouble? Can it make people angry enough to sue you? Yes, it can.
Well, lastly, I just had one more question for you. If an employer does decide to go down this employee monitoring route, they've considered the laws, they've considered the ethics, how should they best communicate to their employees that they will be using monitoring software? Are there specific policies or steps that they should take?
They should communicate it in every possible way they can think of. You start with a policy. You disseminate that policy. You have the employees sign something that says, yes, I got the policy and I understood it and I had an opportunity to ask questions about it, and I did, and my questions were answered. Or if I didn't ask any questions, I didn't have any questions. You do all that. You train on it periodically, at least annually. You give it to all new employees. And one of the best things that I have ever seen, and I certainly didn't come up with this, but boy, is it useful, is that when each employee logs into their computer, they get a pop-up that states the policy, says you may be monitored, you have no reasonable expectation of privacy here, and you have to click yes, or I agree, or type your name in, or whatever. And you have to do that every time you log in. I have even seen that extended so far as to require that kind of an acknowledgement, moving from one area of the computer system to another area of the computer system. I've seen that in a public utility, which of course is extremely security sensitive. Even have to enter passwords. Now that's not practical and it's not necessary for the vast run of businesses. But boy, if somebody sues you for invasion of privacy and you can pull up 15,000 instances over the past 10 years where they clicked, yes, I understand, I have no expectation of privacy, I think you're going to be able to establish no expectation of privacy.
Well, that was all that we had for today. Thank you, David, so much for joining us. And thank you guys for watching this video at home or at work. If you like this video, be sure to give it a thumbs up. And if you're interested in more business related content, subscribe to our channel.